What's up, everyone? Kevin Carrillo here, and welcome to another episode of the Cannabinoid Connect podcast. My guest today is Dave Branfman, IP and trademark attorney at Branfman Mayfield Bustarde Reichenthal LLP. Dave Branfman, how you doing, sir?
I'm doing great. Thank you very much.
It looks like you're having a great time. For those who are listening, Dave has this amazing Zoom background where there's a palm tree actually waving on the ocean. So, yeah, man, you're in paradise. It looks like, huh?
Well, yeah. I mean, I wish I was in Hawaii, but it's not so bad that I'm in San Diego.
Exactly, and that's what we were just talking about before we started recording. I have never been to San Diego, and everyone that I talk to is like, you know, it's the best city in California. It is amazing. It's so bike friendly.
Yeah.
That drive up the coast. What is that drive?
That's it goes by various names. It's called the Coast Highway. It's called 101. Some places it's called 1. But basically, yeah, you can take a surface road pretty much from the Mexican border to Canada, except for a few little chunks that are cut out here and there. But for the most part, you can pretty much go from Mexico to Canada or Canada to Mexico along the beach.
Wow, that's amazing. That's something that I have on my bucket list. One day I want to make that drive. I've done the whole drive through the Colorado Rockies up to like Breckenridge and whatnot.
Right.
And
sure.
And that was amazing. But I need to.
You've done the Continental Divide up there, and.
Yep. Yeah. So I need to do the West Coast. Dream drive, we'll call it. So
yeah, it gets it's pretty addicting out here.
Yep.
I can't, like I said earlier, when you and I were talking before, I came here in 1975 just for 3 years to go to grad school, and I was here about 6 minutes, and I realized I'd rather live here and visit New York, where I'm from, than live in New York and visit here. But I'm a spring and summer guy.
Right.
I'm not a winter guy.
And you got to be built for winter if you're living in the Northeast, yeah, because those winters are brutal, man.
And the summers are worse.
Yeah, it's partly why I think those people are so tough out there.
Partly.
Young people, you know.
Sure.
Yeah,
sure.
Absolutely. Yeah. Well, hey, I'm really excited to have you on today. We're going to be talking IP and trademarks as it relates to the cannabis industry, but before we dive into that, I gotta say, I did some research. I Googled you, and I watched some videos and stuff, and I love your firm's slogan. I think you said it's fast cars and weed, but not at the same time.
Yeah, that's our unofficial slogan. We haven't really made that our official slogan yet, because we're not sure how the state bar would take. Yeah, that's kind of because we have a lot of clients in the cannabis industry, and we have a lot of clients in the aftermarket auto industry. Anything that goes on or in a car after you drive it off the dealer's showroom, that's called aftermarket auto. And so, yeah, we like cars. We like fast cars a lot.
Got you. Well, I own my own social media marketing agency, and I'll tell you, I thought it was very clever, especially backstory like that where you serve two different industries, so it even makes more sense.
Yeah, thanks.
So you're an IP and trademark attorney in the cannabis industry. How did you get started doing this?
Well, it kind of happened over time. I've been an intellectual property attorney, and intellectual property is the umbrella term for trademarks, copyrights, patents, trade secrets, domain names, products of the intellect, innovations, inventions, stuff like that. Intellectual property is kind of the umbrella term. And I've been doing that kind of work for all kinds of industries: restaurants, clothing, entertainment, aftermarket auto, electronics, for almost 35 years. And then about 11 years ago now, it dawned on me that as the cannabis industry kind of morphed from this underground rebel economy and a purely medical marijuana type of arrangement which is what it was up until 2014 when Colorado, Washington, Oregon went adult use, AKA recreational. It dawned on me about 10, 11 years ago that as the industry morphed, it was only a matter of time before more and more entrepreneurs were going to get into this. Cultivators and manufacturers were really going to start expanding the scope of their work and what they did, and that as new people and investors and entrepreneurs came into it, it was only a matter of time before people were going to start asking questions like, gee, that's great. It looks like you have a nice business there, Mr. Cultivator or Ms. Manufacturer. But if I want to invest in your business, how do I protect my money? Where are the assets? Where's the intellectual property? Where are the copyrights, the patents, and the trademarks? Because that's how investors think. So it dawned on me, like I said, about 10, 11 years ago, that there was going to be an opportunity to blend my interest and knowledge and expertise in intellectual property law with the cannabis industry. And having grown up in the 60s and been exposed to a lot of things, I'll just leave it at that, this was a natural for me.
Right. Yeah. You just kind of naturally, you saw what was coming, that there was going to be legitimacy within this industry at some point. They would have regulations in place, especially living in California where, so progressive, right?
Yeah, we had, it was legitimate in California. I mean, to the extent that we had a medical marijuana regimen set up. There was a medical marijuana process for being able to grow it and distribute it, but it was hampered by some of the vagueness in the law, and it was hampered by the fact that it was medical only. But I saw that it was going to change, or I perceived that it was going to change, and that it was only a matter of time before adult use was going to come online. And I mean, back in 2009, 2010, you didn't have to be a rocket scientist to know that adult use was coming, rec was coming. But for most people, looking 4 or 5 years down the road is too much. But having been through a lot of different life cycles of new industries, I mean, when I started practicing law, there were no computers. I mean, we used to dictate into these little dictaphones with these little mini cassette recorders. So I've always been kind of at the cutting edge of stuff. So I could see that rec was coming, and then that was going to blow open the whole entrepreneurship and invention.
Well, that's a unique perspective that you have, right? Because I didn't think about it from that viewpoint. You've actually seen multiple industries kind of front explode, right?
Right.
Lifetime. And for me, I'm sitting back fascinated by the cannabis industry, particularly now that hemp is you're able to grow hemp at a massive scale across the United States. And I didn't, I was too young basically during the internet boom. You know what I mean? I lived through it, and I'm not like, I'm a older millennial, but I remember all the transition of going from cord phones to, the brick cell phone to the Nokia playing Snake on it, and
right.
So it's incredible that you were in a position as an adult to pivot and shift into that industry with an entrepreneurial mindset,
Yeah, it's one of the fun things about doing this kind of law is intellectual property law. By definition, you have to you're always out at the cutting edge of whatever is new and happening. I mean, I remember when my law firm back in 1984 or 1985 was cutting edge, and they bought everybody in the firm so-called portable computers, which were as big as suitcases and weighed 60 or 70 pounds, and the screen was this big, and you actually had floppy disks. That's where all the data was kept, on actual 5 1/4 inch floppy disks. And then, there was this big big change to CD-ROMs, where you could have the entire encyclopedia on 6 CD-ROMs.
Do you remember Encarta?
Yes, I remember Encarta. I also remember when we got our first fax machine. Whenever a fax would come in, everybody in the office would stop what they were doing, get up, and walk over to the fax machine and just watch the paper come in and roll off the machine on that crinkly thermal paper that only lasted a couple of months.
Right.
But fax machines were so revolutionary, people would have to stop doing what they were doing to just watch a fax come in.
That's so.
Yeah, so then we went to higher speed computers, and then of course the internet was the next really big game changer.
Yeah. Well, so I mean, and it's clear, right, with everything that's happening in the cannabis industry, there is so much potential for just growth in so many sectors of the industry. I mean, it's insane. So before we jump into all that, I want, I'm a serial entrepreneur myself, and I have a high level understanding of the differences when it comes to IP versus copyrights versus patents versus trademarks versus all this stuff, right? So for our audiences, why don't you just kind of break down the definitions of each and why they're important for the cannabis industry?
So let's start with sort of a basic definition of all of the 4 main tools, I call them. And by the way, I have a nice little handy dandy chart. I don't know if I showed it on the screen, whether it would appear, but I've got a nice little 1-page chart called the 4 basic tools, and I compare copyrights, patents, trademarks, and trade secrets to each other on 5 criteria. If you want a copy, I can send it to you. And
send it to me and I'll add it in. Yeah.
Okay, great. Okay. So copyrights protect content. C for copyright, C for content. By content, I mean pictures, drawings, illustrations, computer programs, books, screenplays, motion pictures, any kind of content that you can get out of your head and onto a piece of paper or computer screen is considered copyrightable authorship. So, in the cannabis industry, that can be everything from pictures of your weed to your website content, to any manuals and instructions that you write, any guides, any videos that you shoot. Even sometimes if you have a highly graphically rich logo, the graphically rich logo, like the Wendy's girl, the Wendy's hamburger girl with the red hair, that can be protected by copyright as well as trademark. So any kind of content can be protected by copyright.
So to stop you there on the copyright side, so what I've always been interested in is, okay, you have vehicles like social media, right, to distribute content. So, I mean, you mentioned, like, as one example being an image of a flower, right, that you may have posted and whatnot. Like, from a social media marketing perspective, you would want that photo to be shared. But at the same time, you would want to get authorship or at least credit for that photo.
Right.
So can you talk about like the stipulations and the legalities when it comes to social media marketing and copyright infringement?
Yeah, I mean, we could probably talk about that for 5 hours, but we'll try to kind of, sort of boil it down to something digestible. There's this tension between tightly holding on to something and owning it and really restricting how it's used and making sure that if you're the photographer or the cinematographer or the videographer, that you get paid for every single use. That's one extreme, the tight as a fist extreme. And then the other extreme is get it out there and let the world see it and let them come to you. And everybody has to kind of decide for themselves where they want to be on the spectrum. They don't have to be at either extreme. They could be somewhere in the middle. But the reason copyright law exists, and this is one of the things that kind of fascinates me about American history and politics and how it relates to all of this, is the founders of the country, in the 1800s, before anything, I mean, before light bulbs, before electricity, before automobiles, certainly before computers, before all of this, they had the wisdom to write into the US Constitution that the Congress has the power to protect the inventions and creations of authors and inventors for limited periods of time. It's out of that, Article 1, Section 8. I don't want to get too technical on anybody, but it's a little nerdy thing that I do. That they realized that in order to encourage people to invent stuff and create stuff, you had to give them the right to kind of control it for some period of time so that they could get a return on their investment. Otherwise, if an inventor and a creator can't try to monetize what they do, then they may not be able to do that. They're going to have to go get a job somewhere else to pay the rent and put food on the table. So that's where copyright law and patent law and later trademark law all came from. This idea that we have to incentivize people to invent stuff and create stuff for limited periods of time. So that's why patents last now for roughly only 20 years. Copyrights last for the life of the author plus 70 or 75 years. And trademarks have different periods of time, the different criteria. So we've all got to decide, like for example, my little IP chart, okay, that I created. I want it out there, but I put a copyright notice on there and I register the copyright with the Copyright Office. And it's up to me to decide if I want to put it out there, if I want to give it to you and say, okay, Kevin, you have the right to put this up on your show, and you even have the right to make a copy of it. And if any of your listeners or viewers want a copy, you can make a copy of it. You have my permission to make a copy of it and send it to them, but that's my right. Okay. Right. Now, if a book publisher, if one of the top 10 book publishers wants to put that in a book and make money off of it, I might say, hey, time out. That's a different situation. If you're going to make money off of it, I'd like to be compensated too. But I have the right to do that by protecting my copyright, by putting my copyright notice on my material, and by registering the copyright and being careful about how it gets out there. I have some say in how that's used.
Sure.
And I think that's what everybody who does social media has to think about.
Yeah.
Is and the corollary to that, and this is one of the number one issues that I grapple with clients all the time and out when I'm speaking and fielding questions, is just because you see something on the internet doesn't mean it's automatically free for you to use and appropriate any way you want. It may be copyrighted, and the person who put it up on the internet may have the right to say, hey, time out, not so fast, cowboy.
That's right. Yeah. And I know that because like say you do a simple Google search and then you click on the images tab, right? There's a section where under tools, I believe, where, it says copyright use, and it says available for reuse, not available for reuse. They filter those images that are okay to use and those that aren't.
Yeah. So I'm not sure that answers the question, in a more or less usable plain English way, but I hope it does.
No, it does. It does. And it makes sense, right? Because social media is a new platform, right? It's like a delivery vehicle, and it's something where the nature of social media is to share, right? So everything that you said makes total sense. It's really up to the person, the owner, the business owner, to decide, what they're willing to give up and what they're not, right? And If your objective is to drive traffic to who you are and get attention, then you got to put content out. I mean, there's no way to do it. But
That's right.
yeah, I mean, but if you have a business where you just rely on word of mouth and you don't need external promotion, you may not want to give away too much, right? But if you do give me that chart, I will give you credit because I don't want to screw with the IP.
Well, you'll see my little yeah. I'm the last guy on earth you want
to. Exactly. You will be getting credit. Don't worry, Dave.
I have my little copyright notice on it, but it's a great tool. And I've actually gotten compliments from lawyers that I've spoken to, like at Normal conferences. You're familiar with Normal, right?
Mm-hmm. Yes. That's the reform group, right?
Say again?
It's the Cannabis Reform group, right?
Yeah, National Organization for the Reform of Marijuana Laws. Really, side note, everything we have today in terms of decriminalization of marijuana, recreational use, adult use, whatever you want to call it, hemp laws, is all because Keith Stroop and others founded NORML, National Organization Reform of Marijuana Laws, like 50 years ago, when something like 13, 14, 15% of the population only favored legalization of marijuana, and they've been fighting this fight for 50 freaking years.
Those are the OGs right there, man.
They are the OGs, and I urge everybody to check out normal.org. Check them out. Make a $5, whatever you can donate, because they're still fighting the good fight, and they are really my heroes, because all the organizations that you see now, all the other organizations, they all came later, but NORML's been fighting this. Anyway, so when I speak to NORML,
what do you think the percentage is now, in terms
around 65%?
65% of public support?
Yeah.
That seems lower than what I thought.
Well, I'm not an expert in polling and favorability, but that was the last number, about 65% that I heard from Keith, who's the co-founder or founder of NORML, at a conference a year or two ago. So it might be higher.
Still higher than 50%, which is great. You know what I mean? So, I mean,
and it's enough to get, it's enough to get more than half the states to decriminalize.
Right. Yeah, there's too many. I mean, the Last Prisoner Project is another great organization, right? I mean, you talk about some of these cannabis businesses being deemed essential, and then you have people locked up for cannabis-related offenses. It's crazy.
It's crazy. And that, I say this to a lot of my clients too. I remind them that, being in the cannabis space, whether you're a cultivator or manufacturer, distributor, retailer, whatever, it's not just a business, it's a movement still. And I encourage my clients to, allocate some of the money that they're making for the Last Prisoner Project or NORML or other organizations that are continuing the fight to decriminalize.
Yeah, this is going to sound way out there, but I would almost say it's life, in a way that where it can stimulate job growth, it can employ people. It's a plant that helps the earth, right? It takes in massive amounts of CO2 emissions, which is good for our planet. You can feed our livestock, and with the seeds, you can make things out of this plant with its fiber and its herd. It's incredible. And then the medicinal purposes, we're just scratching the surface on that.
Oh yeah, just scratching the surface.
Due to Schedule I regulation. And so, that brings up actually a really good point that I wanted to talk about. And that's, in my last podcast, I had Rod Kite on. He's an attorney in the cannabis industry also. And we were talking about the contradictions of the federal government, right? How they've listed cannabis or marijuana, as they use the term, as a Schedule I narcotic. And under that classification, there's no medicinal uses for it, which obviously there are. But at the same time, the government has patents for
patent. The one you're talking about, the main one you're talking about, expired last year, but yeah, they had a patent for 20 years on using certain kind of cannabis extracts to treat ischemic diseases like stroke and dementia. And if you read the patent, and if you'd like, I'll get you a copy of it if you haven't seen it.
Yeah.
The patent, the summary of the patent in the beginning, if you didn't know better, you would think it was a commercial from Normal, touting the benefits of cannabinoids.
Right.
It's incredibly hypocritical.
And is that the only one you're saying? I thought.
I'm not saying it's the only one, but it's the main one.
Oh.
That the government, I don't pretend to know every patent or every cannabis patent that's out there, but it's the main one that I'm aware of, that the government has had literally for the last 20 years, and it expired about a year ago.
Wow. Well, what about in the private sector? What are you seeing in terms of, like, are there large companies, tech companies, maybe like Amazons of the world or whatnot, that are looking into cannabis related patents?
Well, I mean, big business, big pharma, big tobacco, big alcohol, they're all looking at this. They're looking, and depending on how you look at it, they're either dipping their toe or they're jumping in. For example, Altria, which is the parent company of several cigarette companies, has made a giant investment, to the tune of a couple $2 billion in, I think, canopy growth in Canada. You don't make a $2 billion investment because you're dipping your toe in this and waiting to see what maybe might happen, right? I think that means that they're sitting up in Canada and they're learning everything they can about how this works and how the cannabis ecosystem works, both in terms of everything from growing it to manufacturing it to distributing it to how you sell it, how it gets regulated, et cetera. And they're just waiting for the US to get on board, because it's really hard for a big company like Altria to launch a product in the United States if they have to grapple with 50 different states' regulations. They're going to wait until there's something akin to national legalization or decriminalization, leaving it up to the 50 states, let's say.
Right.
We don't know which way it's going to go or when it's going to get there.
Do you?
But yeah, big business, to answer your question succinctly, which is hard for me to do because I'm a loudmouth New Yorker. Yeah, big business is in. They're in, and they're going to get in.
They're going to get in. Yeah. I mean, I would imagine, because it's only a matter of time. As you said earlier, public support is at 65%, if not higher. So eventually Deborah Borchardt was on, and her perspective, which I thought was pretty spot on, was that it's gonna, the states are gonna basically like overturn the federal requirements. More states, the majority of the states are gonna be either decriminalized or recreation, and it's gonna force the federal government to deschedule it. So who knows?
We think, or it's gonna leave this hodgepodge of laws in 40 or 45 of the 50 states, and there's still going to be a problem with transportation across state lines. We don't know.
Yeah, that could be an issue also.
That's another place where intellectual property gets really important, because let's say you own some copyrights, you own some trademarks, you own some patents, you own some trade secrets, or some combination of them for your cannabis products, let's say, but you're stuck in California or New Mexico or Pennsylvania, and you can't transport your products across state lines. What you can do is you can become a licensing enterprise based in whatever your home state is, and then find operators in each one of the states who are competent and licensed and know what they're doing, and they can take a license to your intellectual property, which is like renting, if you will, your intellectual property in their state, and produce your products under your guidance in their state, and you can receive a royalty from that. you know, if you know anything about surf clothing, Hang Ten and HP, you ever hear of those guys, those
Oh,
brands? They're
mm-mm.
like classic California brands, been around for 60 years. Hang Ten, you know, for surfers, and
Mm-hmm.
OP for Ocean Pacific. They don't make a stitch of clothing. They used to 60 years ago. That's how they got started. But now they're purely licensing companies. They manage their intellectual property licenses uh, around the world. They
So,
have licensees all around the world.
so you're saying it's basically like a white label service?
Well, I wouldn't, not white label. I mean, I think of white label as um, I'm a manufacturer. I make a really good I make a really good gummy bear, and you know, you've got a brand, but you don't know really how to manufacture, and you want me to put, you know, you'll pay me to put your brand on my product. This is different. This is where I'm the manufacturer of you know, Uncle Dave's gummy bears, right? I'm the original. I got the formula, I got the patent, I got the trademark, I got all the rights to Uncle Dave's gummy bears, right? But I can't ship it across state lines from my home office in California. I'll find somebody in New Mexico, in Arizona, in New York, New Jersey, wherever it's legal, and to make Uncle Dave's gummy bears using my formula, my trademark, my packaging, under my supervision. As a licensee, they'll be able to do that. They benefit from my name brand recognition. I benefit because they can do it in New York or Arizona, and I can't. It's kind of like a franchise.
I was just gonna say that. I was just gonna say, so like a franchise. Yeah. Okay.
It's
That
kind
makes.
of like a franchise. Yeah. There's
Okay.
some franchise. I don't want to get too technical or too legalistic. There's some franchise laws to be careful about, but the concept is that because there's this prohibition against transporting weed across state lines, that or anything that contains weed across state lines, that you can have experienced operators in different states or different countries use your intellectual property to produce a product according to your specifications.
Right. No, that makes a lot of sense. Thanks for breaking that down and making that distinction. Yeah. So when we talk about those protections that you're saying, with the 2018 Farm Bill being passed, obviously allowing mass cultivation of hemp, like we talked about earlier, I from what I've read, we're now in a position where we can apply for U.S. trademark applications.
In some cases.
What's that?
In some cases, in some situations.
In some situations. So let's talk about those situations and
Sure.
what are the purposes of those certain protections?
Well, let's jump back just a half step to why bother getting a U.S. or federal trademark registration? Why even bother? Well, it's nice to be able, if you have a brand, Uncle Dave's gummy bears. If I own Uncle Dave's, the trademark Uncle Dave's, and that's got some name brand recognition, having a federal trademark, or if my brand is Mrs. Fields or Famous Amos for chocolate chip cookies, or Xerox for photocopy paper, if I have a registered trademark and somebody infringes, steals my trademark against my will and without my permission, having that federal trademark registration gets me into court quicker and easier, and makes it easier for me to get a judge to tell the bad person to stop. So there's a big advantage to having a U.S. federal trademark registration.
Is there a difference among industries when it comes to trademarks? So, for example, my experience in the tech industry, or let's take tech out of any industry, right? If you have the same company name as someone, the same trademark as someone, it's okay only if you are in different industries. Is that right, or is that?
Well, that's a pretty good summary of the general rule. And let me give you a couple of examples. That's why Delta Airlines and Delta Faucets can coexist. Airlines and faucets for your sink, two different industries. The public isn't likely to be confused when somebody sees Delta faucets and think, oh, do those have anything to do with Delta Airlines? Or when somebody gets on Delta Airlines and think, gee, is this the same company as the plumbing company? No. Same thing with Champion Auto spark plugs for your car and Champion brand t-shirts. No likelihood of confusion. Now, what if you have, I'm going to make this up. What if you have Champion for beer and now somebody comes out with Champion for wine? That's a lot closer.
Because they're both in the alcohol industry. They're both, right?
Correct.
Right.
Now, what if somebody comes out with, now Mrs. Fields is well known for her chocolate chip cookies. What if somebody comes out with Mrs. Fields pancake syrup? Is that too close?
I don't know. They're both in the food group, right? So right. I would say now, that would be.
If somebody comes out with Mrs. Fields sheets and pillowcases and doesn't use her logo, is that too close? Maybe, maybe not, because Mrs. Fields is really famous. So there's the spectrum of not close enough at all. Champion spark plugs versus Champion clothing, Delta faucets versus Delta Airlines, not close enough at all, where neither one of those trademark owners is going to be able to sue the other, to where things are a little bit closer and there could be some confusion in the marketplace where one could sue the other. And that's one of the other interesting things about trademarks, which, by the way, definitionally are brand names or logos or anything that identifies and distinguishes one product from another. That's what a trademark is. The interesting thing about trademark law is, one of the interesting things about it, again, a little nerdyism, is trademark law doesn't exist just to protect the interests of the trademark owner. Trademark law also exists to protect the interest of we as consumers, or us as consumers. We have the right to know when we're driving down the road in a strange town, like you come out to California, you've never been to California, and you see a McDonald's, or you see a Burger King, or you see a Wendy's. You have the right to know that if you stop in there, you're pretty much going to get the same Big Mac there that you got back home in Dallas. It's not some rogue person, some rogue hamburger stand making, a Big Mac using inferior products. Right. So there's actually a consumer protection aspect of trademark law. So let me bring this home to the cannabis industry. So if Willie Nelson has a brand of weed, Willie's Reserve, right? Mm-hmm. You have a right to know that when you shop at a pot shop or a cannabis shop in Denver, and you see Willie's Reserve OG Kush, and you see Willie's Reserve OG Kush in a pot shop in California, it's going to be the same thing. Right. And that's where trademark protection is really important.
And does that even, so as we talk about trademarks and patents and copyright, I want to get to the side of genetics, right? Like, is there a lot of patents going on when it comes to new genetic strains that are being created?
Well, I don't know if there's a lot, but there's definitely action in the genetics area. But you got to prove, it's tough because you got to prove that your strain is new, novel, and non-obvious. So if you just blend, AK-47 with Blue Dream, is that new, novel, and not obvious? I don't know.
Right.
But there's definitely a lot of action in that. And there's a lot of action in all the processes that are being used to extract things more quickly and cleanly and more organically. So there's all kinds of patent action in processes and equipment and lighting equipment and irrigation equipment. And what's interesting, again, kind of a nerdy thing, nerdy lawyer, IP lawyer thing, is it's called the Patent and Trademark Office in Washington, D.C., but they have, figuratively, they have two different doors. There's the patent door and the trademark door. If you walk in the patent door and you file a patent for a new strain or a product that, or a device or an invention, a machine that touches the cannabis and does something with it and extracts it better, you're not going to get rejected because cannabis is illegal under Schedule 1 if you walk in the patent door. But if you walk in the trademark door, you're going to get rejected if the product that you're trying to get your trademark for is either cannabis or contains cannabis or touches cannabis. And the reason is there's a specific section in the trademark law, the US trademark law, that says the trademark office is not allowed to grant a trademark registration for anything that's illegal. There is no such specific section in the patent law. That's why you can walk in the patent door and get a hi, how are you? And you walk in the trademark door and it's thumbs down, except for hemp and hemp-derived products such as CBD, which contain less than 0.3% THC, so long as they're not orally ingested. That's what's developing in the law now in the last year and a half since the Farm Bill was signed into law on December 20th of 2018, ironically by the commander-in-chief, I guess. That's a separate story for another day. But so the trademark office is now, the US Trademark Office is now allowing trademark registrations for hemp and products that contain CBD with less than 0.3% THC, so long as they're not orally ingested. And the oral ingestion issue is not a Schedule 1 problem, it's a Food, Drug, and Cosmetic Act problem, because the FDA, the Food and Drug Administration, is taking the position that anything that goes in your mouth, even if it's hemp or CBD with less than 0.3% THC, violates the Food, Drug, and Cosmetic Act. So we've got a problem with that. There's an issue there.
Protecting big pharma, right? I mean,
maybe I try not to get too much into the politics.
Dragging their feet, in other words. And yeah, I mean, I get it. Go ahead. Sorry.
But now you've got, if you have a hemp-based or a CBD-based sunscreen, shampoo, conditioner, lotion, cream, something you can be applied topically, you should be able to get a trademark registration for that, as long as your trademark isn't generic, geographic, and doesn't conflict with somebody else's trademark.
Right. Well, let's talk about, okay, like with the FDA regulations, I know that there are some good things that are happening. Like, you know, while we do understand that there are medicinal uses for cannabis, specifically the cannabinoids found in the cannabis plants, such as CBD, CBN, CBG, you know, the FDA has, I know they've hammered some companies and really brought them forward for misleading customers with false marketing. You know, for instance, like this will
don't make any health claims.
Yeah, don't make any health claims, right? And that's, we've seen companies get dinged and get in trouble for that during this pandemic because they're saying it'll help coronavirus, right?
Yeah, crazy.
Yeah, which is doing a disservice to industry overall, right? Because we're learning every single day, and these scientists and these geneticists are working really hard to understand. You know, I had Dr. Zach Hildebrand on, and every day they're working to figure this stuff out, and it kind of sets us back whenever these false claims are made. You know.
Well, there's that, and I'd say the corollary to that on the trademark side, and I may get some hate mail for this, but I'm down on trademark parodies in cannabis for a similar reason. So, every once in a while you'll see somebody comes out with Hashies instead of Hershey's, or Ganja Joy instead of Almond Joy, or Starducks instead of Starbucks. I love creativity, don't get me wrong. And I love a good joke, and I love a good parody. But I think in the cannabis space, that stuff plays into the hands of the haters. It plays into the hands of the reefer madness crazies and what that does is it gives them a weapon to say, the children, the children, the children, look what you're doing to the children. Let's not give them that weapon.
Well,
let's be creative and come up with our own good brand names. What do we need to parody somebody else's for?
That's such a good point. And you know what? It seems like the CBD market is taking a different route. Like, sure, there are CBD products that are, infused in energy drinks and all, there's gummies that have more sugar in the gummy than actual CBD, right? But you also see this marketing angle of health and wellness, especially when it comes to athletics. There's CBD companies that are sponsors of the MMA of UFC.
Yep. I'm a pickleball player. I don't know if they have pickleball out in Texas. It's it's kind of a cross between ping pong and tennis, and it's played on an outdoor or indoor court that's about a third of the size of a tennis court. But a lot of people up until their 80s can play pickleball even if they can't play tennis. And the club I play at, they've got a sponsorship deal with a CBD company.
Yep.
Because there's so much, joint pain and pain relief that's provided.
And
so for sports, it's fantastic.
And that's what's so fascinating, right? Is that there was so much stigma put on that specific cannabinoid THC.
Yeah.
Which everybody, and to no one's fault, just because the lack of education and knowledge due to it being a Schedule I drug, for the last 40 or 50 years, people still associate the entire plant with that one cannabinoid, and it's really, really important that we remove that stigma and we understand, okay, THC is a psychoactive. It has psychoactive compounds, right? It gets you high. It does this. You smoke CBD, you're not going to have that high effect. You're going to feel, relaxed and you're going to have less anxiety. And so there's different things that each of these things does. I've heard that CBN is a good sleep aid,
Yeah, I've heard the same thing. Yeah.
Yeah, so I think that the CBD market, that particular market angle, when it focuses on health and wellness, I think that's really the way to go, because it allows people like us to have conversations where we're learning more and talking about each cannabinoid and the medical properties that they contain.
Yeah, I agree 100%. And like I said earlier, NORML's been fighting this for 50 years, and we may be. It's up to us to help the younger generation get away from these stigmas and open up their minds and be able to look at this stuff critically. Now, don't get me wrong. I'm not to date myself too much, but I have grandchildren. I don't want my 8, 9, 10-year-old grandchildren smoking weed that's got 25% THC in it. I just don't. I don't want them drinking alcohol or, taking OxyContin either. So I've got to.
And they've even said that THC isn't good for younger kids as their brains are still developing and growing. It's not something that's good for, which is why, of course, there should be regulations in place, 21 and over. But I think we both agree that the education should be there, because our bodies have endocannabinoid systems that marry. They're receptors that marry with these cannabinoids, right? It's almost like a natural biological thing that we're conjoined with. So that needs to definitely be taught, to the future generations, because that's what's really going to help move the needle.
Sure. And that's what's helped move the needle in the last 50 years. is my generation, which was in high school in the 60s, is now, they're now on city councils and state legislatures and in Congress and all over the place.
What do you think about the weed now compared to when you were in high school? Like,
It's the difference between a rocket ship and a go-kart.
there's some baby.
There's no comparison.
There's some baby boomers that I know that like won't even touch it. They're like, no, I can't smoke the stuff that's grown now because it's just so strong, that they avoid it.
I'm more, at this stage of my life, especially because I'm really, really active in sports and stuff. I am, for whatever reason, better or for worse, for me, CBD is much more consistent with my lifestyle.
Yep.
Than THC.
I have a business partner who's the same way. Yeah. He prefers CBD over THC.
But that's what's great is now there, as you said a couple of minutes ago, there's this wide range of products and choices that all stem from the one plant. So let's explore that, and let's everybody find out what's best for them, and let's get people off of OxyContin. Let's get people off of these heavy duty drugs and onto something that's going to provide them with pain relief, anxiety relief, stress relief, whatever it is that they need.
Absolutely. Yeah. And remove that physical dependence. That's
right.
That's one thing with those pharmaceutical drugs like OxyContin, like you mentioned, and hydrocodone and all these pain pills, is that your body physically yearns for it, once you're not on it. And if you're accustomed to taking that, it's a hard road. Whereas you don't.
I've been very lucky. I've never been down that road before, but I've heard about it from many, 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 many people and read a lot of articles, and it's tragic. And I could see how easily it could happen. I'm lucky. I've never broken anything. I've never needed any kind of pain medications. But I have a friend who broke her back, and her back got broken in a plane crash. She's been on painkillers for 30 years now.
Exactly. And I have similar stories. I mean, people I knew in high school that had, football injuries, they broke their leg or whatnot. And for years they were being, prescribed this medicine, where you just, it's habit forming and it's not good, but, we've talked about a lot, Dave, and I do want, to pick your brain and share some advice and expertise to someone maybe thinking about starting in the cannabis industry. How can they protect and monetize themselves during this time, especially during COVID?
Well, I mean, the first thing is, if you're going to start growing, distributing, manufacturing, or retailing, you're going to have to hook up with a cannabis lawyer, or a lawyer who specializes in cannabis business law, so that you can make sure to be legal in your state. And that even within your state, you're operating legally within whatever town or city you're in within your state, because some cities say no, even within a state that says yes, a city can opt out. So you have to have, I think the first step is to get with a lawyer who specializes in your state in the formation of a proper cannabis enterprise, if you will, or business, for whatever it is that you're going to do. And get yourself set up legally from the get-go, so you don't run afoul of the law, because, we think weed is legal all over the United States, but it's just decriminalized. So you don't want to be on the criminal side of the decriminalized equation. Then the next step is, once you get organized legally, so that you know what you're doing or what you want to do, you can operate with legally. Then you find somebody like me in whatever state you're in, who can help you go through what it is that you're doing, cultivating, distributing, manufacturing, retailing, or whatever, and go through the four main tools: copyrights, patents, trademarks, trade secrets. Go through the 4 main tools, see what you have now, if anything, or see what you want to develop, and then develop an action plan to start creating and protecting those assets in a logical sequence, and build up as many of those assets as you can over the next 1, 2, 3, or 4 years. That's what I often do with clients, is do a little bit of, they come in and they, well, I want to get into this business, or I got into this business 6 months ago. I want to do some IP protection. First thing I got to do is I got to diagnose what they got and where they're going. And then I can prescribe a course of action. Well, I recommend these 10 steps in this sequence. Do you want to do all 10 right now? Or do you want to do the first 10 now? Or do you want to do the first 2, now, and then the next 2 next month, and then next 2 the month after that? How do you want to sequence it out? And by the way, internet domain names is also a big part of this. I put that under the category of trademarks there. I view them as a subset of trademark because they derive from trademark law.
Oh man, yeah, domains are so important. I mean, obviously for your web presence, right? But even to have like corresponding business emails, that is tied to your domain.
You're a digital guy. What do you think? I love asking digital people. It's 2020, halfway to 2021. If you can't get the .com version of your name, if the .com version of your name is gone, but you can get .us or .co or .biz or .tv, do you take the non.com domain name and run with it, or do you move on to the next name that you can get the .com version for? Meaning, in other words, is .com still the whole enchilada?
So .com is important because people are familiar with .com. If you are really set on your business name and you can't find the .com, but you love the business name, I would advise going after something like .co or .io, something that's like trending, that you see a lot about, not like whatever, VZ or something that looks kind of or spammy. But .com is not, it's ideal to have if it's available, but it's not the end all be all because of SEO. I mean, search engine optimization. So the more good content that you put out and the more presence you have within social media and whatnot, when people type in your name, Google is going to crawl and rank you, So the .com doesn't outweigh any other dots.
So if you have a great name / trademark and that's really great, but you can't get the .com, you don't have to abandon it.
I wouldn't abandon it, no, because you're starting from scratch again, right? And if you're confident in your business, I mean, you're going to win that SEO. You'll get those that page ranking on page 1.
I've seen that recently. Not to get too political, but one of my favorite websites lately is this website called LincolnProject.us, and they went to .us and they're getting the eyeballs because they're spending a lot of money on marketing, and people go, oh, LincolnProject.us. Okay, fine. That's easy. I can go there.
Exactly. And when you talk about search engine optimization, to put my nerdy hat on now, there's so many different aspects that it takes into account for SEO. So your social media activity, the way your website is optimized, the content, if you have a blog, right, the more long form content that you could write with keywords, Google ranks all that stuff. But of course it's got to be good. People got to be interested in what you're doing to be, you got to drive traffic to your website. And
I'll share a strategy with you. My internet domain name strategy slogan is one is not enough. And by that, I mean, let's say these guys have, let's say I have UncleDaves.com for my edible company. If I can also get UncleDaves.biz, .tv, .us, I'm going to acquire 10 or 20 versions of that. Not that I'm going to put up websites. I'm going to have all the other ones point to uncledaves.com. But what I want to do is I want to occupy internet real estate.
Exactly.
And I don't want the competition to get uncledaves.biz or .tv. And I'm also going to get, believe it or not, here's a weird strategy for a lawyer. I'm also going to get uncledavessucks.com.
So that if there's any backlash or what, are you anticipating?
I want to be able to, well, the more popular you are, the higher the likelihood there's going to be a hater out there.
That's true.
Some of the haters get, trademarksucks.com as a way of flaming and annoying whoever it is they're annoyed at. So if I get uncledavessucks.com, I've now blocked them out. I'm also going to get uncle-daves.com and a couple of misspellings. I'm going to type Uncle Dave's really quick, and however I mistype it, I'm going to get that also, because for every 100 people who type in uncledaves.com, 10 are going to mistype it. I want to capture them too when they mistype it. So I'm going to say for every trademark or brand name, I recommend, if the client can afford it, buy 10 or 20 domain names.
That's exactly, if they can afford it, do it, because
cheap insurance.
Like you said, it's a way to own that real estate online and then point back to your main page, right? So even if they make a mistake or if they type in the wrong .com or .io or whatever, you're still getting that website traffic. So that is a good strategy. I would also recommend that you create a Uncle Dave's is awesome.
Oh, that's a good one.
So that you add.
I like that. That's cool.
To it too. So yeah,
I like that. That's good.
Yeah. Well, hey Dave, I really appreciate the time, man. You've shared a lot of great advice when it
My pleasure.
to IP and trademarks and copyrights and patents. And I think that after this episode, people are going to have a real better understanding of what all that means and how it's important for their business. So is there anything that you want to plug, like websites or social media accounts before we end?
Oh, thanks. So my email address is dave@bmbr.com. Bob, Mary, Bob, Robert. Dave@bmbr.com. If you have any questions, kind of a general nature, I'll try to help or send. I've got a lot of articles that I've written about trade IP in general and IP for the cannabis industry. I'm happy to share. And then every Tuesday at noon Pacific, I've started to do, this summer, I started to do a Talking Trademarks Tuesday where I go on Instagram Live. My Instagram handle from 20 years ago, I've stuck with it for better or for worse, is my last name is Branfman, right? My Instagram handle is Branfdog, because that was my favorite. I had a dog once named Branfdog. I was Branfman, Branfdog. So my Instagram handle is Branfdog. And noon Pacific, I do Talking Trademarks Tuesday on Instagram Live. Pick a couple of topics, a couple of new cases, chat a little bit, talk about just like we're doing today. Sometimes invite on a guest. Maybe I'll invite you on and we can talk about trade, IP and domain and digital strategies.
Yeah.
And then I open up for Q&A. So happy to invite people to that. And you can tell me someday down the road if I should migrate over to Facebook or, LinkedIn or something.
Sure. No, that sounds great. Y'all heard it here. So every Tuesday, Talking Trademarks with Dave Branfman. Sorry, Dave.
That's okay.
So, but I appreciate your time again. And
thank you very much for opening this up. It's been great.
Yes, absolutely, Dave. Well,
if you want to do it down the road, let me know, because there's new developments all the time. And, so sometimes we'll come back in 3 or 6 months and there'll be something new and exciting.
Let's do it. I'd love that. Yeah, absolutely.
Thanks, Kevin.
Well, thank you everybody for listening. We'll see you next time.
See you next time.